Welcome to the Lane Gorman Trubit Expanding Your Horizons webinar series. This event will focus on the automotive dealership industry. Art Lambert, attorney at Fisher & Phillips, presented on recent changes and developments within the industry, including developments in workplace safety in the times of COVID-19, EEO and no harassment laws, new wage and hour regulations, and union avoidance. This webinar was recorded live as a Zoom webinar on April 29th, 2021, and all information was accurate and up to date at that time. If you have any questions regarding this webinar or future CRT webinars, please feel free to email us at askus@lgt-cpa.com and we will get back to you as soon as possible. Thank you and enjoy the video.
Hey everybody, there should be some emails coming out giving y'all updates on future roundtable meetings that we'll be having through Zoom, and most importantly, October. So October, as you know, for those of you that have been attending for a while, we usually have our June and October controllers roundtables in person. And our goal is, and our commitment for this October, unless everything just goes crazy, is we're going to be having our October meeting in San Antonio at the Mocara, which is where we've had it in the past. So let's everybody stay positive and keep healthy, and then we can have it and get some normality to this, kind of to add to our lives. So anyway, good to see y'all here. Looks like most people have already gotten logged in. I haven't seen it bump up much recently. So I'm Colin Kanalakis. I'm a partner with Lane Gorman Trubit. Spend a lot of time in dealerships, 95% of my time. Got Patrick Riley here, our other partner with Lane Gorman Trubit, just like me, dealerships all the way. We're lucky today to be welcoming Art Lambert with Fisher & Phillips. He's worked with Steve Rapolo and our dealership clients and many of you for a long time. He's going to bring a lot of great knowledge and updates for us on dealership world and how things have changed, and probably talk a little bit about how things are going to change and or stay the same in the future. As a reminder, Lane Gorman Trubit, we're a Dallas-based CPA firm, deal with clients throughout Texas and a lot of the surrounding states. And dealerships is our biggest niche, and we really live and breathe dealerships, and happy to be presenting this educational update for you guys. All right, I'm going to turn this over to Raina Tu. She's going to give a brief introduction, talk about Fisher & Phillips and how they help your dealerships, and then she'll introduce Art to get this started. So thank you all for joining us today.
Yeah, thank you, Colin and Katie. My name is Raina Tu. I'm based in the Houston office with Fisher Phillips. I support the Denver, Kansas City, and Dallas offices. Fisher Phillips has about a little over 450 attorneys with 36 offices across the U.S. We're definitely an employment law firm with a variety of different practices and specialties, with automotive being one of them. So for today, we're definitely excited here to present with you guys with our partner, Art Lambert, who's going to deep dive into the automotive industry with a lot of the latest developments and, hot topics and things you should be aware of. So I am gonna flip it over to Art. With no further ado, take it, Art.
All right, thank you very much. Welcome everyone, and it's great to see so many bright and shiny faces out there. Just kidding. That's kind of one of the unfortunate parts of it. I'm very tired of the whole Brady Bunch screen thing, as I'm sure everybody else is. I absolutely prefer to communicate in person. And if you've seen me at any of the LGT seminars, you would probably understand what I'm talking about. So what we're going to talk about is we look back at last year and see how it's changed. And it's actually the last year or two, because they have slid in together because of the amount of time we've had, our amount of time that's passed before people have really been able to absorb what's going on. March 11th, we had the global pandemic. It actually started a little before that. March 18th, the FFCRA was signed into law. April 1st, unemployment hit 15%. April 24th, the PPP got signed into law. So it was a boring 2 months for us in the legal profession and for all employers. May 2nd, murder hornets arrived in the US. They were actually a welcome distraction. Nationwide BLM movement, June 6th. June 15th, Title VII was altered to protect LGBTQ individuals, which again was interesting times for employment law, employees and employment lawyers. November 3rd, presidential election, pretty boring, I think, fairly standard presidential election as far as things have gone. So what now? We've got COVID-19. We're still dealing with that. We've got social justice issues and employment laws that are really moving along quickly. Really moving along quickly. So the answer to this is training, is what we always say. Managers, because managers, not just HR people, but the managers on the floor have to be aware of what is new and what they need to be aware of, and what they can and can't do. I always say one of the issues with dealerships that we have is in which HR people have is that you're dealing with very verbal people, right? People who are socially skilled, and these are people who are on the floor at all times, sometimes with a lot of time on their hands. So things can happen, and things do happen that we need to keep people aware of. That's why we try to emphasize training. We're going to talk about today what's happened in workplace safety in the time of COVID-19. I get asked a lot of questions about this. It used to be I get asked a lot of questions about these kind of things at cocktail parties, but I haven't been to a cocktail party in quite a while. So most of the time I get asked these questions via text or email or telephone. EEO and no harassment laws, what are the changes that we're looking at there? Some of the new wage and hour regulations are actually sometimes in the interim, since we've had our last time we've talked about this. If you came to the last one, the wage and hour regulations have actually flip-flop. They've changed, then changed, and come back to the other place again. And union avoidance. This is actually a lot of territory, and we're going to try to cover. Workplace safety. There's the OSHA General Duty Clause, which is essentially every employer has the duty to maintain a safe workplace. And how much does that include mitigating and preventing the spread of COVID-19 in the workplace and vaccines? We're going to talk about that. That's a fairly new issue. As far as mitigating COVID-19 in the workplace, what we recommend, these are the recommended things. Sometimes this is harder to do in practice than it is in theory, is assign a workplace coordinator. You can do a hazard assessment depending on your industry, depending on whether or not you think there's a hazard. You can identify measures to limit spread. One of the common things is to eliminate the number of people that are in a break room, things like that. Some places are staggering schedules. That's not always so practical in the dealership, so you try to think of things. Sometimes if you just take into consideration what you can and can't do, you've actually created a workplace safety plan without even realizing it. Establish a system for making sure you communicate with workers in a language they understand. And that in Texas is a problem always, particularly. Education and training on this. Whatever policies we're going to have, we need to make sure that the managers are aware of it and that the employees are aware of it. Because if we have a policy and we don't train people on the policy, if we have a problem later down the line, we're going to see issues because we haven't followed our own policies. I always tell people, don't have a policy if you're not going to use it. Sometimes people have, I don't know, some sort of HR policy about reporting, or you need to tell your managers if you have workplace relationship or things like that. And my first question is, has this ever happened in the past, and have we enforced this in the past? And if people say we haven't felt the need to enforce it yet, then I usually recommend don't get the policy. There's nothing worse than having a policy that you don't use. Minimize the negative impact of quarantine and isolation. That the CDC provides guidelines on that, and I can't really give you too much of an opinion on that because you are aware as well as I am that the CDC's guidelines change very rapidly, and including enhanced cleaning and disinfection after a suspected or confirmed case of COVID-19, even though the CDC has said that's not maybe necessary, we still recommend that if for no other reason than it creates some comfort level for the employer and the employees. So also, we can give you, if you have any questions, and this is probably not appropriate for this particular seminar, we can give you guidance on screening and testing protocols, things like that. There are certain requirements for recording and reporting COVID-19 infections and deaths in some states, not in all states. Anti-retaliation protection, for instance, people that have taken COVID leave. That's if we see litigation peak or come up because of COVID, that's where we see it, is where people are not alleging that they got COVID at work. Excuse me. What they're alleging is they took COVID leave under the protections and were retaliated against for that. It's just like FMLA retaliation, just like harassment retaliation. You can also have an anonymous process for employee complaints. One of the nice things about this, so this goes back and forth. When I do manager training, the feedback I get for employee complaint, having like a complaint box, is that they get people whining in the complaint box. My response to that is, well, what I'd rather have is the whines, so I can figure out at that point where there are problems and where there are not problems, and not figure it out. Because if people don't have a process for complaining, then they don't complain until it becomes a big deal, and then it's too late. Then you have to end up having to call me, and nobody really wants to be calling me. And the other thing we say is don't relax preventive measures unless you're sure that doing so is appropriate and can be done safely in your workplace. Vaccines. I get asked a lot of questions about this. Dealerships can mandate vaccines. People ask me that all the time, and I tell them you can mandate a lot of things. If they don't want to work for you, they don't have to work for you. But you have to consider accommodations for employees with disabilities or religious objections. And if you give incentives to vaccinate, for instance, as some companies are doing, that can pose risks on their own. Here are the issues you need to consider before you proceed with a vaccine mandate. We have some clients who absolutely want to mandate vaccines because they think it's a way to get everybody back to normal and kind of give them a free pass. We've got others who are really against it. I can tell you that pushback against employer mandated vaccines has stirred a lot of media attention. All you need to do is Google employer mandated vaccines and you'll see all the good and the bad of it. First, one of the issues is you want to identify the concerns among your workforce and provide information to help employees understand how vaccinations can reliably promote health and safety for themselves, coworkers, and others. Give them information about the safety or for the numbers on the vaccines. Give them information about how, by doing so, it would allow the business to come back to full usage if you can, things like that. Give them the information. This will help them in the long run because it's helping everybody. Take into account the unique environment at your business. Sometimes the unique environment can be just how everybody feels politically, or what the strongest opinions are, or what the opinions of the dealer is. So you need to figure out the best way to communicate your policy to the employees, including how much notice to provide before implementing the requirement. One of the things we like to do is send out educational blurbs about vaccines before we do any type of policy about vaccines. Even if it's just encouraging vaccination, we would send out things, and what I would do is not send out my own things. I would send out CDC notices, things like that, that talk about the pros and cons of vaccination and the risks that are there. Consider related logistics, including compensation issues that may be implicated. Those would be, for instance, if we're making people vaccinate, do I need to compensate somebody while they go and get a vaccination? You need to talk, that's, and again, a specific issue depending on the person's position and depending on how we treat other like issues. Make sure we have a clear, reasonable accommodation policy to address religious and disability issues in any vaccine policy. Any vaccination policy, I believe, should include a reasonable accommodation policy, even if we already have it in the handbook, because we want to make sure we emphasize to people that this is something that's not going to be, they're not going to be retaliated against. We've got accommodation and we want them to come talk to us, and that we'll take every individual's concern and look and give it careful, confidential consideration. Also spend a little time considering how your employees and your customers are likely to respond to the policy. For instance, if you're going to get negative press, nobody understands how much, well, actually we do because we deal with dealerships all the time, but how much of a neighborhood business dealerships are. Even the dealerships that are owned by multiple or have multiple facilities, each facility is kind of a community center. And a lot of people operate on trust. So you need to look at your community. You need to kind of analyze that and take that into consideration. If you're in a small town, for instance, in West Texas, that may create a different consideration than if you're a dealership in Dallas, for instance. Yeah, any type of policy, pro or con, may receive a different response. Also, you consider how and when the protocols may change as employees become more fully vaccinated. OSHA may not substantially relax its recommendations for individuals who are fully vaccinated. And OSHA has some recommendations that are fairly easy to see as to how to maintain a safe workplace under pandemic protocols. And you might want to consider developing a designated team for coordinating this entire process. And that could just be the manager and the HR person, or the CFO, or the controller and the HR person, something like that. It doesn't have to be too complicated. Okay, EEO and no harassment policies. Companies are taking the lead now because of so much press in both directions, in every direction. It seems like years ago, people would say, I'm worried that if I get sued for this, it's going to end up in the press. And I'd say, look, you're not going to end up in the press. They don't really care that much about it. In every sexual harassment case, they get filed all the time. Nobody cares. Well, now it's a very hot topic. So you need to make sure that you try to avoid it. And as a result, a lot of companies, a lot of clients are taking the lead. The customers are the audience that we're taking the lead for. It's how we're presenting ourselves to the customers. And that again goes back to what I was talking about how each dealership or each facility needs to understand its constituents. And the employees are also the audience. You need to understand what your employee base is and what your policies are going to be. You need that. Just thinking about these things will give a company or a dealership a better understanding of exactly how diverse the world is in which we work in, how diverse your company is, your dealership. Hashtag Me Too contributes to the rise in sexual harassment complaints. That's absolutely true. And it's, I say it's similar to the Clinton, Monica Lewinsky thing, where we saw a big uptick in sexual harassment claims after that. And it's just because people become more aware of the issue, and people become more sensitized to the issue, and people become, frankly, more sensitive to the issue. And it gets talked about in the workplace. Sometimes these things end up becoming a problem because somebody will say, did you read such and such a person is suing such and such a person? What a crock. Well, you know what? That's not really an appropriate thing to say at the workplace all by itself. And in a dealership where people are just sitting around talking because they're waiting for a customer to come in because it's early in the morning or it's in between time, rush time, then they get into a debate. That's a debate we'd really rather not have, because it's a debate that usually goes down a rabbit hole of, well, I think that, fill in the blank, the protected class are too sensitive about this. And somebody else says, well, I don't think so. I'm in that protected class and I think I've been treated blah, blah, blah. Same thing with the Black Lives Matters issue. It contributed to a rise in race discrimination claims because people are more sensitized to the issues, more sensitized maybe to wrongs that they've received in the workplace. And also, again, this is not just dealership, but places like this, salespeople, people with sales forces that congregate, people talk about it. And when people talk about things like that, interesting things happen. Let's put it that way. COVID-19 concerns contribute to a rise in age discrimination cases because people get ill from COVID-19 or more afraid of COVID-19 or take greater precautions from COVID-19. And so they then say that what you're doing is the reason why you've taken that action is because of your perception of their age. So that's an issue to be aware of also at this time. Also, ensure compliance with laws that govern the workplace. This is something I say every single time, and I will say it every single time. I've been practicing for 30 years. I've probably given training in those 30 years more than 900 times. And I always talk about ensure that what you have is in compliance with the laws that govern the workplace. Make sure you do an annual review of a handbook. It doesn't have to take that long. Nobody likes handbook work. Attorneys, frankly, don't like handbook work. It can be tedious and the process can be long, but make sure you conduct that because you want to make sure that what you have is the proper policies in place so that you can have the proper, so that your employees are on notice as to what their expectations of conduct and the expectations of the conduct of others are. And that will provide you with an appropriate defense to whatever claim they may have. For instance, they knew they should have complained and they didn't complain, or we had a policy in place and this person violated the policy. And when we found out, we took appropriate steps. Those are great things to be able to say to do. And like I said, and arbitration agreements are something you may want to consider depending on the number of employees you have. But I would talk to your lawyer before you discuss arbitration agreements because there's pros and cons to that too. Sometimes depending on what jurisdictions you're in, sometimes depending on, again, what your business model is and how you want to handle these things. And like I said, the review of the handbook, that's something we do and often do on a flat fee basis for people because it's important, especially now. Wage and hour, we'll talk about dealership exemptions. There's the new minimum wage, which has gone back and forth. And of course, we can talk about how we can modernize our pay plans. So the litigation landscape, this is for everybody, but it's also for dealerships because I got to tell you, there are attorneys that specialize in wage and hour lawsuits, and those more wage and hour lawsuits, for instance, are filed in the state of Texas than any other employment claim. And so these people often have dealership exemptions on their radar because we have some very specific dealership exemptions. Tens of thousands of FLSA, Fair Labor Standards Act lawsuits have been filed in the last 10 years. There's been over a 200% increase in these suits filed in the past decade. I put those numbers in just so people pay attention. They're both individual claims and collective actions, which collective actions is a class action. It's where all your employees or all your employees in a certain class sue you. And the two main areas for these lawsuits, particularly with dealers, are unpaid overtime, basically because they're misclassified. Like we say they're exempt, which means they aren't subject to overtime, and they say they're not, or off the clock work, where we have people working off the clock. And that happens sometimes. It's not always that people are lying about that. Sometimes managers are under pressure to meet budget. And when we have that, they may be telling somebody, don't punch out, but you need to finish your work, or you need to clean your service bay. Everybody's service bay needs to be cleaned, but nobody's allowed overtime. So if you can't get it done, you got to do it on your own time. And you can count on it. This will continue. It's been this way ever since I've been practicing the law. These lawsuits have gone up and up and up. All right. What's the rule for us? Dealership exemptions. We've got the white collar exemption, which is essentially the executive exemption. I'm a supervisor. I work in an administrative capacity, or I'm a professional, though there aren't that many in dealerships for professionals. Dealership has some specific overtime exemptions. There's sales. The salespeople are specifically exempt from overtime. Mechanics, parts people, service writers. There are other available overtime exemptions, and we'll talk about these specifically. Commission paid employees under Section 7I of the FLSA and the Motor Carrier Act. And what do you need to know? Effective January 1, you have to pay everybody a salary of at least $684 a week to meet the minimum salary requirement for a non-overtime person, an exempt person. It's supposed to remain the same this year, and it has so far this year. So that's for a salary basis requirement. The requirement still applies each pay period. It's not annualized. So it's not like we can catch up. It means each pay period, they need to be paid that amount. Salary basis and deductions. This includes having a safe harbor provision in the handbook. And what a safe harbor provision is a provision that you can put in, and you can do this yourself if you'd like. It's a safe harbor provision that you can put in that says if anybody is aware that they or think that they have a problem with how they're getting paid overtime and they don't believe that their position is being paid properly, they need to talk to us, and we will try to do an investigation into it as soon as possible. That limits our damages and gives us the opportunity to go back and correct. Be mindful of deductions that recoup overpayments. Be mindful of any deductions in Texas for that matter. Make sure that you're doing it properly. For instance, if I'm an exempt employee, I can dock somebody's PTO for a partial day of absence, but can I actually deduct their salary for a partial day absence if they're an exempt person? And the answer is no. And there's no minimum service requirements for use of paid time off. In other words, we don't have to say, we can take the paid time off in any way, shape, or form, just as long as we have a policy for it. Minimum wage right now is currently $7.25 an hour, and that can vary at state and local levels. There are some cities there are some cities that have different minimum wages, and there are definitely some states that have different minimum wages. There's a proposal to increase this to $15 by 2025. But if you guys have lived through the last 3 years where the minimum wage and the exemption issue, how much salary basis was going to be required, changed at least twice, you'll understand you need to keep an eye on that. And this could have an impact on dealership exemptions because no matter what, these dealership positions, as we're going to talk about, need to be paid minimum wage. Also, we need to make sure we have Equal Pay Act compliance. And the Equal Pay Act provides that we need to pay all genders equally. We can't pay different people different jobs. And that includes, in the dealership context, different opportunities. I can't, if I have two different tiers of salespeople or two different tiers of sales positions where one has access to greater commissions than others, say fleet sales, and I only have guys in the fleet sales, for instance, and I've never had a female in the fleet sales, even though the qualification appears to be you're in the top 5 of your sales class, something like that. That could be an Equal Pay Act issue. That's just an example. Guarantees or incentive pays go into our pay plan issue because they go into our consideration as to what type of pay becomes overtime pay and what type of pay does somebody get credit for in terms of whether or not they can become exempt or stay exempt. And also our pay plans can be the defense against an action for a breach of contract or fraud that somehow we've brought somebody in and told them they would have this pay plan. And then in the end, what we've had is, we've paid them under this other pay plan. So a pay plan, and the other thing about a pay plan that's good, it's good for employee morale, because one issue we see all the time in dealerships, or not all the time, but I see in dealerships and in all sorts of sales positions is conflict that arises generally from a misunderstanding over how somebody's going to get paid. And it's nice to be able to say we have this written plan and this is what we follow, and therefore we can go back to it. At the very least, they have to say, oh, I didn't realize that. I feel better now. And sometimes they don't say that even then, but at least we can feel better about it, whether we're paying them provided by a written sales plan. Always good. Some dealership specific exemptions. Sorry for the small writing. The salesperson exemption, that's the one that's most common. That's somebody whose primary duty, more than half of his or her time each week, must be the sale of cars or trucks, the ultimate purchaser. The pay plan doesn't matter so long as he or she receives at least minimum wage for every hour worked in the week. In other words, the commission plan or how we pay it doesn't matter as long as they get at least minimum wage for that jurisdiction for every hour. So salespeople are exempt. Internet sales can be exempt as long as there's some negotiation involved, and that becomes a point of dispute. So we've had some people who have had internet sales, and all they are leads people. They get the lead and then they transfer the lead over to a salesperson. And we've tried to say that these internet salespeople are exempt under the salesperson exemption. So that's something that the Department of Labor doesn't agree with, and we need to be careful about. Service writer, the exempt, the exempt status of service advisors has been in constant flux. Since I've been practicing law, I've seen probably 8 major decisions about this, and the Department of Labor has had a bugaboo about this. If anybody has been in HR for more than 5 or 8 years, they'll know that this is flip-flopped around. However, we had a case, Fisher Phillips actually had a case and convinced the U.S. Supreme Court early, actually this is early last year, sorry, to put the matter to bed once and for all, winning the case that confirms that service advisors are not entitled to overtime premium pay under the Fair Labor Standards Act. That includes the people that fall under salesman exemption also. Non-exempt are people, are arguably non-exempt, are aftermarket specialists, BDC employees, product specialists, greeters, motorcycle salespeople can be non-exempt depending on what they do, because the exemption goes towards cars or trucks, not motorcycles, and sometimes an F&I manager, and we'll talk about that also. Partsman exemption, that's what it's called even in this day of Equal Pay Act issues. It's currently under attack because they don't view, or at least the argument is that partsmen are not people who have the same type of sales responsibility that some of these other people have. So a partsman, in order to have an exemption, their primary duty, more than half of his or her time each week, so it's a part person's exemption, must be selling, issuing, requisitioning, or stocking parts. The pay plan doesn't matter as long as he or she receives at least minimum wage for every hour worked in a week, just like the salesperson. So exempt is a parts counter person, a shipping and receiving person. A stocker or picker could be exempt depending on what their actual duties are, and same thing with a telephone salesperson, depending on what their duties are. Non-exempt would be a delivery driver or a clerical or inventory, or just a stocker who doesn't have any contact with the public or our clients and selling or issuing or requisitioning the parts. Mechanic exemption, kind of a little bit of a funky one. The primary duty of the mechanic must be more than half of his or her time each week be the performance of mechanical repair work on cars or trucks. Again, this is a specific dealership exemption, and then the pay plan doesn't matter. So exempt are service tech trainees, metalmen or bodymen, aftermarket installers. The idea being that these people have some involvement in selling or selling our products to people, our customers, clients, customers, and or vendors. Non-exempt are quick lube employees, painters, detailers, get ready employees. These are aftermarket or after client, not client facing or vendor facing employees is how they're regarded, and they're not listed in the exemption. And there are cases that say these things. So again, be mindful of what the primary duty of that person is. And a lot of times we can have 2 or 3 mechanics in a facility, and one of the mechanics doesn't actually meet that because they are doing too many other things. So they sometimes work as a mechanic, sometimes work as a painter or a detailer, or in the quick lube shop. So we need to make sure that we can account for more than half of their time, because the burden is on us to prove it. And often people are fine with the way they're paid. And often with overtime issues, what we find are people don't want to have their pay plan changed. They consider almost a badge of pride that they're on a salary, that they're a salaried employee, that they're making X number of dollars. And they're concerned that if they go into an hourly rate, that they might end up making less, and somehow they consider it to be an inferior position. But if it is so, it's too bad. And we'll talk about what we can do about that a little bit. Section 7I is the compensation. So it's a great backup exemption for a lot of positions at dealerships. It has to be employed at a retail dealership, and it's with people who receive the majority of their compensation through commissions. And they receive at least 1.5 times minimum wage for all their hours worked in an overtime week. In any hour that they've worked more than 40 hours, they have to make sure that for those 40 plus hours, they've received at least approximately $11 an hour. This is also available for F&I, but again, also under attack. And partly because, so some employees are paid on a flat rate basis. In California right now, there's a case in front of the 9th Circuit Court of Appeals. When I say California, it's almost with a shrug, because everything's under attack in California on a wage and hour basis. But it's something to be aware of. and something to keep track of. So how do I stay in compliance? You can do a reviews or duties test. This is not, doesn't have to be quite as, again, just like the handbook test, though this could be easier. It doesn't have to be quite as onerous as it seems. You can do this test. Well, first question I get asked all the time, what if none of the dealership specific exemptions apply and I'm left with one of the white collar exemptions with the new salary minimum? The question we need to ask ourselves is this position really exempt under the duties test? And the duties test depends on which exemption we have and is specific to the position and to the individual. Not to job descriptions, not to pay classifications, not to job groups or conventional wisdom. I argue sometimes you can have two people with the same description, same job description sitting side by side, and one person's actually exempt and one person's not, primarily because one person has an increased amount of responsibility that we've given them or that we've allowed them to take because they have shown the ability to handle increase. And that actually, because of the discretion and increased responsibility, that pops them into an exempt case, whereas a person next to them we think is kind of a schmo or new or just not somebody we want to give that kind of responsibility to. So even though they have the same job description and the job description sounds on paper like it should be exempt, it doesn't necessarily mean that they're all exempt. So detailed. So, and the other problem I have with job descriptions and relying on job descriptions is often they're out of date. Often I'll look at a job description and they'll be from 10 or 15 or 20 years ago because job descriptions are a pain, just like handbooks, and nobody really likes to do them. One of my tips for job descriptions, because my next bullet point is detailed, accurate, current job information is essential, is make a review of the job description part of a manager's review of their employee. So if every manager has to do job review of their employees, an annual review of their employees, staple to that review that you give to them or send to that review that they need to fill out and affirm that that job description is accurate. And I would try make it some sort of format where each bullet point of the job description needs to be checked off or clicked or highlighted by the manager. And that's part of their job. And that goes into their job review every year as to whether or not they have actually updated the job descriptions for their employees. It's just like reviews. When managers don't do reviews, I say, well, that goes into the manager review. Because this way we can actually take a look and make sure that the job description is based on the actual work and real facts. Because sometimes sitting where we are, it's hard to tell. A lot of times it sounds like that's right. And sometimes the manager will say that's right because they aren't really thinking about it. But then you go over each job, each bullet point by point, they go, yeah, no, we don't really need that. We don't really need that. We don't really need that. An example is years ago, there was a carrier service that said they had to have a 60-pound restriction, or 80-pound lifting restriction, which eliminated women and smaller people. And they got sued for it and they lost because it turned out that really they even had a policy themselves that if they had large packages, they got put on different trucks. So those different trucks could be manned by different people or staffed by different people that could lift that 80 pounds. So that 80-pound requirement was an old-fashioned requirement, yet we were still hiring and or firing people based on that. And they actually had like an 80-pound box with handles that they would make people do at application when they came in for the interview. Can you lift that box? Well, they didn't actually have to lift that box for most of the positions in the company. And job descriptions are helpful, but as I've said, they alone don't make employees exempt. It's actually what the employee does. And if we've taken the responsibilities away or added responsibilities, like I said, that can change how that employee's exemption applies. And if we determined that the exemption doesn't apply, we take a look and we're thinking, this person's working 45 hours, 50 hours every week, and I don't see that they fit into any exemptions. They're not supervising anybody. They don't fall into a dealership exemption. They don't really have any discretion. So what do? We use this as an opportunity to reclassify, and there's different ways we can do this. There's different strategies we can use depending on the size of the dealership, how many people are involved, things like that. But we use this as an opportunity to reclassify that position and avoid our problem. And if we have a safe harbor provision in our handbook, we can use the safe harbor provision also. And third, if the duties test is satisfied but the salary is too low, with the considerations, we can increase the salary or we can convert to hourly plus overtime. We can take a determination, take a look at what hours they've been working, if we've been keeping track of those hours, or do a ballpark on it and determine which we want to do, which would be a pleasant surprise for the employee, probably. Um, but the problems are here. So what should you do? Exemption aside, are you sure you're 100% in compliance? Because here's what happens. If we're going to change somebody's pay plan or a group of people's pay plan, that's going to make people talk, and you're going to have your jailhouse lawyers or dealership sales floor lawyers, people who have time on their hands are going to say, hey, I should have been paid this. We all along should have been paid this. We have a cause of action for the amount of time they haven't paid us this way in the past. So again, that helps when we have a safe harbor provision. It also helps if we have some strategy for how to deal with it. There's different ways to roll this out. And we've been fairly successful in doing this because we've had to do it, the law firm, probably hundreds and hundreds and hundreds of times. I mean, it's not an unusual thing. As a matter of fact, it's a fairly usual thing when we do a pay audit. When somebody asks us to look at their pay, it usually means they have questions and they want to see what we think. So find out. It's easier to find out now where you stand, especially if it's been a while since you've looked, because it's easier to find out now than have some plaintiff's attorney send you a demand letter and then you find out. You call me and I say, well, I got to tell you, according to the law, it looks right to me. The demand letter looks correct, and we just need to figure out how we can get rid of this thing. Other thing is to make sure you're accurately recording work time. Make sure managers understand that all time worked has to be recorded. They should, and make sure employees understand this. It's okay to make people, one of the things we do is also make sure we're properly computing overtime, make sure that any type of deductions we make. Whenever I hear about taking deductions, particularly in Texas, which has a very stringent deduction policy where you have to get specific permission for each specific deduction from employees, I get concerned about it and it raises a flag. It may not be a big flag because we can usually cure it pretty easily, but it's a flag nonetheless. And the other thing is, and this is a pet peeve of mine, I put this in every single wage and hour presentation I do. Actually, what I usually do when I'm in person, I ask people to raise their hand if they have independent contractors working for them. And however many people raise their hand, if I've got 50 people in the audience, usually 30 to 40 people raise their hand. And I say, okay, out of the 40 people who are raising their hand, 35 of you are wrong, at least part of the way. Most of the time, and this is something the DOL has placed a point of emphasis on last year and for this coming year, our independent contractors, you need to make sure that if somebody's an independent contractor, that they fall within the independent contractor definition. There have been some weird cases and some weird findings about people being independent contractor, even if this person does the same thing they're doing for you for 3 or 4 other dealerships. For instance, I had a dealership that had a paint detail guy come in, and he was a contractor. He would come in, do his thing 2 days a week, and then go work at other dealerships. And what they found is because he worked for us steadily, or what they alleged is that because he worked for us steadily, the DOL's position was he was not a contractor. Just something to be aware of, things to think about. Non-compliance consequences, unpaid overtime wages based upon employee records. Because the problem is usually if we have got unpaid overtime wages, it's not something we've recorded. In other words, we're not keeping track of the time they're there. Sometimes we have our exempt people have sign-in sheets, which can help if we have that. But it's going to be otherwise, the presumption is the employee's records, they come in and they always say, I work 60 hours a week every week I work there. And I only got paid for 40 and I never got paid overtime, but every single week I work 60. 60 is like a magic number and they never say 43 or 44. So it's the presumption if we don't have records is that is going to be correct. And then we have to go through all these different things to try to prove that's incorrect. So not only would we be liable for the unpaid overtime wages, which is of course time and a half of all that time, but an equal amount, it's called liquidated damages. So whatever amount it is, if it's $10, we're going to owe $20. And civil money penalties up to $1,100 a person. It's a 2-year limitations period, 3 years if it's willful. And it's almost always found to be willful. in court-ordered compliance in the future, possible contempt of court if there's other violations in the future. Here's some other non-compliance consequences that I also always like to go over, because this can be the biggest thing. I have a case right now where the maximum damages looks like it might be under $10,000, and because this person has just lied, and we've actually have some way of keeping track, and she's alleging hundreds of thousands of dollars. But the kicker is we need to figure out some way to get out of this, or reasonably get out of this, because we are going to be responsible for their attorney's fees, even if we end up only paying 10 grand. We'll pay the 10 grand plus liquidated damage, which means $20,000. And then we'll pay their attorney's fees, which would be a lot more than that. And of course, you'd have to pay our attorney's fees also. Also, the Fair Labor Standards Act, unlike Title VII, is one of the few times where there's individual manager liability. If they find that an individual manager has made the decision to classify these people as exempt, and if that person is still around, they can sue that individual. And sometimes in dealerships cases, they'll sue the dealership and they'll sue the dealer or the general manager of the dealer individually. There's possible criminal penalties. I don't see that happening unless you are a repeat offender. And of course, there's the diversion issue. There's distraction and disruption of the workplace, not just the time spent having to deal with me, but the fact that people talk about it. It's because a lawsuit, nothing's more popular to talk about than a lawsuit. I can say wage and hour lawsuit isn't as sexy as a sexual harassment lawsuit in terms of what people are going to be talking about on the floor, but nonetheless, litigation is always popular. Otherwise, all these Law and Order and other shows nobody would be watching them. And of course, today, in this day and age, there's adverse publicity because people are attuned to that. And the Department of Labor is getting more and more involved in trying to get the press interested in what we do and what they're trying to do to us. Union avoidance. There are certain unions that are increasingly trying to go after dealerships, especially because now we have some mega dealerships. And so we have to be conscious of what we need to deal with and how we can handle it. For instance, employee complaints about working conditions, as well as employee actions about unionization. A lot of times people don't understand that an employee complaint about working conditions is actually a protected complaint and protected under the National Labor Relations Act. So that is two employees getting together to complain about a manager treating them poorly is not just necessarily two whiny employees, but they can be two employees engaged in protected concerted activity under the National Labor Relations Act. So we need to make sure that our managers understand before they take any type of disciplinary action that there is a right to engage in discussion of wages, hours, terms and conditions of employment. And of course, there's a protected ability to form and join or assist a union. Of course, we have steps we can take to prevent that, and we do take steps to prevent that all the time. We actually have a union avoidance group that is a fairly successful group and has been successful with dealerships in the past. But you should make sure that your managers understand that that's a protected activity. One way to keep this from occurring that we always talk about when we do union training is to make sure that everybody stays connected to your employees. Make sure we understand that what we can do to cultivate good working relationships and good working conditions. Because if employees are happy, they really aren't going to want to, really are less likely to want to rock the boat. That's the complaint box thing. Again, I had an employer who took down their complaint box. And I was like, why'd you take down the complaint box? Because just a lot of people putting in whines. And again, I'd rather have the small whines that I can figure out, I can deal with, because there might be a big whine in there, or I might hear that such and such a person has a potty mouth is actually one that we got. Well, okay, I might want to talk to that person. I might want to go to say, Art, you need to really tone it down. This is not appropriate on the work floor, on the sales floor, not only because it can offend other employees, but because there could be clients or customers around that you don't know, and they can hear that, and that reflects very poorly on the dealership, for instance, just to give you a for instance. So there's no guarantees, but I do have some tips that I always try to help people. I try to leave people with Make sure you evaluate your compensation plan. Wages and benefits are the biggest attraction for a union, or the biggest place where a union can come in and try to attack you. If you make sure your pay is competitive, and if you've got any pay errors, try to address them as fast as possible. Job security is an important thing. I don't want people to promise anybody to take jobs that they have job security, but if you communicate with your employees about the status of the dealership, the business of the dealership, things are good, things are not, things are well, they can often create some quietude in the employees and create happier employees. And make sure that you're providing breaks and lunches that are consistent with the applicable law, and consider creating a regular break schedule so people can take advantage of it. Same thing with PTO. Make sure your PTO policies are in compliance. There are a lot of people who have multi-state dealerships, and their PTO policies are not necessarily in compliance with all the states, because some of the states have some tricky policies. Make sure you maintain a safe and sanitary workplace, because if people feel like too many people are getting hurt, or if that they have to work in a filthy environment, that can create unhappiness. And again, engagement. Give people an opportunity to resolve their disputes. The small disputes are so much easier to resolve than the big disputes. Sometimes, a lot of times, these complaints we get, we can investigate. It takes 5 minutes, and we can say, okay, we're going to talk to Colin and tell Colin to stop doing that. And we expect Colin to not do that. And we can tell Colin, if you do that again, you'll either get ridden up or terminated, depending on how serious it is of whatever it was Colin was doing. And that'll stop. And that helps people think, one, that you care, two, that the policy works, and three, it gets them to stop the behavior. And the fourth thing is, if somebody doesn't complain in the future, we get to use that as a defense, because we can say, well, if they complained even about such a small thing as what Colin had done, we take steps to take care of that complaint. So they're banned from coming after us because they failed to use our complaint policy. The PRO Act. Okay, this is the Pro Union Act. It reinstalled quickie elections, and this is not something you necessarily need to know specifically unless you have a union issue coming on, in which case you need to contact legal counsel as soon as possible. Even if it's not us, it's got to be somebody. It expands the pool of potential union members because it's substantially narrowed. Used to be supervisors were not capable of being in a union, so they weren't subject to the anti-retaliation provisions and things like that. This is substantially narrowed the definition of supervisors, therefore expanded to people who can organize and engage in concerted activities. It has rules. It has changed the rules and how we permit workers to use company equipment, and whether we can permit workers to use company equipment to engage in union activity. And it prohibits us the hiring of permanent replacements in certain specific conditions. So be proactive in minimizing employee dissatisfaction. Also, make sure you train managers on employee reactions, and make sure you take proactive measures. Actually, train managers on employee relations, and make sure you take tips or take these tips to heart to prevent union efforts. These are the things that we can deal with. Those are the points I've made, and I know I've talked very fast. I always go through my slides faster than I think I'm going to. So now what I'm going to try to do with Katie's assistance is see if we can deal with questions.
Great. We do have a couple of questions in the Q&A. If you have any, please input those now. So what is defined as skilled work for a technician to be considered eligible for the flat rate pay?
Oh, well, okay. I can answer that live, and I can tell you that I can't really answer that live because it depends on what the technician's doing, and it depends on how skilled they're doing it. So in other words, that goes back to my two people can be standing side by side in the dealership, and one person can be exempt and the other person can be not, even though they have the same job title, because skilled work for a technician can be something such as computer related work in assessing and analyzing things to do with very specific car issues or very special cars. For instance, a Tesla technician now is probably going to have, there's going to be a lot of skilled work in that, or electrical cars. Even dealing with electrical cars, we send people to get certification or special certification. We send them back to Ford or whomever to get whichever company to get their specially certified technician role. That special certification helps us use the exemption for that technician. So that's one of the things. Those are factors that go into place. That's all I can give you is kind of the factors that go in. And I get to ask this all the time. I get asked this every time I do a Fair Labor Standards Act, and they ask me about, what about this one? I'm like, I don't know about this one. I will say, I don't know. But I do answer these questions all the time, but it ends up becoming very specific to the dealership and to that individual. So really it's a question of, is this person doing skilled work that would make them exempt? Can you discuss how employers can and do use social media related to protect concerted activity? Absolutely. Matter of fact, social media is where most of this concerted activity cases are coming from right now. There was a restaurant in New Jersey that fired somebody. Well, it got complicated. So somebody made a Facebook post about a manager and about how that manager was treating people at work, and called them all sorts of names. And the manager was not on their Facebook listing, and it was a private post. But the manager went and took another employee who he heard talking about it and told him, you need to allow me to look at these Facebook posts, or I'm going to fire you. And then the manager looked at the post, was unhappy, and fired that employee. I mean, that's like a textbook case of terrible things to do. And the reason why I bring it up is because it's one of the early, it's called the Facebook case with employment lawyers, because the manager did a number of things wrong. He coerced somebody into giving them a password, which now in New Jersey, you're not allowed to do for sure. And I would say it's not a good idea to do anywhere. But he also used that coercion he threatened discipline for that person actually engaging in dialogue with somebody else on their Facebook post, discussing with other coworkers that they didn't care for this manager or the way this manager dealt business. The NLRB found this to be a concerted activity, and it didn't take them very long to find it. And I got to say, frankly, I always say bad facts make bad law, because for a while we had a very conservative, and then for a while we had a very liberal NLRB. It's swung back and forth quite a bit over the last 5 years, but I don't believe any NLRB I've been under would have found that to not be concerted activity. The only thing that would have altered that would have been the fact that 5 years ago or 7 years ago, some of these people didn't quite understand what social media activity was. And now everybody did. I mean, I remember bringing a case in front of a judge, and I said, this is what they posted. And the judge didn't even know what I was talking about. I don't remember if it was Twitter or it was Instagram, but I had to explain how that worked and what that was. And the judge said, oh, that's all very interesting. And I thought, yeah, it is, except that, it's kind of, and of course, that's what happens. So nowadays, all judges and all people understand Instagram and Twitter. Everybody knows what Twitter is, because we've just had some fairly famous tweets that have been made by some fairly famous people, and those can get people in trouble. So if somebody tweets about your company and it's not defamatory, and in other words, it's not a lie, and it's about their working conditions, we need to be very careful how we deal with that. Hopefully that dealt with that. And if not, ask me a follow-up. That's fine. Is there anything else up there, Katie? Those are the only ones I see.
Don't see any others right now. How can people get a hold of you if they have any additional questions?
So, okay, here we go.
And I did have one observation. I haven't read up on it, but how you'd mentioned about employers incentivizing employees to go and get their COVID shots. And I know that's a kind of a sticky situation to work through, but
right.
There's a potential tax credit that's being proposed. I think it's like $510 per employee. And so kind of the thought about that is that as an employer, you can incentivize the employee by giving them a day off, and you're recouping some of that cost by the tax credit of $510.
That's a great
kind
point.
of a way to maybe incentivize without pushing to the other side of that line.
That's
So
a
any
great point,
thoughts on
because
that?
we've been asked that before, and that's a piggyback on the Wellness Act. I don't know if you remember that coming, what was it, 7 or 8 years ago, where we could lower our insurance benefits for people who don't smoke, for instance. And smokers, of course, complain that they're being penalized. And my response to that was always, well, you're not being penalized. Other people are being rewarded for the fact that they're a lower drain on our insurance plan. The problem with that, and this is not a legal opinion, but it is a practical opinion that I see because I'm being asked this question probably 4 times in the last 3 weeks, is that there's a lot of heat right now about vaccinations and companies' stances on vaccination and whether you're pro or con vaccination. So regardless of the economic benefits, and that's a really good point, and you're much better suited to talk about that than I am for sure, is that you need to consider, again, your community, not your constituency, I call it, your employees and your community, because doing that may make it seem like you are pro whatever and anti whatever, and that can create some backlash. And it's a different kind of backlash than the Wellness Act, because unlike smokers who are hard to defend, or at least have not a lot of sympathy, and I'm not making a judgment on smoking one way or the other, but in terms of the general society at large right now, people are not sympathetic to that issue. Vaccination has a tremendous amount of traction in both directions. So you need to be careful that you have that ability to do that, but before you do it, consider what might happen from that. And, what kind of people get in fistfights over whether or not you should be vaccinated or not at the workplace, mostly because people will get in fistfights over almost anything in some workplaces. But vaccines, like the last election, are very polarizing right now. So just something to consider.
Right. Well, excellent. Sorry I interrupted you. I know
No,
you've got
that
your
was a great point.
contact. You've got your contact information on here now for everybody.
Yeah. And
So
feel free to send me questions if you've got specific questions. Like I said, the problem with wage and hour, I knew that's where most of my questions were going to come from, is because I make everybody nervous with this, right? And they're all thinking about this person. Oh, I've got this person over here and I'm not so sure about them. But usually if you're not so sure about them, first of all, my rule of thumb is they're usually not exempt. Just because you're having doubts about them usually means you're probably right. But then they want me to kind of buttress that and make them, because they need to go talk to somebody else about it and say, see, I told you this person wasn't exempt. But all of that becomes very individualized. Like I said, 2 people in the same dealership, one's exempt and one's not, just because of how we treat them and how we react to them. So.
And my main takeaway as an advisor to dealerships is there's too many nuances in this wage and hour area to make guesses. So, if you're not working with someone that can advise you like Fisher and Phillips can, you should. We have a lot of clients that work with Fisher and Phillips, and they're very happy with the practical guidance that's provided, because it's easy to get rule of law guidance that it's not applied to practicality, and the plain English understanding helps a lot. And I know that's not always the case in your advisor, so I know we all can, right?
And hopefully that's what I communicated today. That's what I try to do, is try to be practical about this, because the law is, what is it, Shakespeare? The law is an ass, but very hard to understand. And,
right.
And wage and hour is Byzantine. And it changes all the time. And there's a million courts, and each court has its own opinion. So like right now, F&I is being attacked in California. Partsman's being attacked in Oregon. I don't think they're going to win in either case. It's going to get overturned. But, somebody's always got a better idea, because the wage and hour plaintiffs' attorneys always think of different things or better things, and they're hoping to find better for you. So.
All right. Well, perfect. Well, I appreciate y'all coming in and joining us today. As always, we really want to know what you'd like to hear about and learn about. So reach out to any of us, give us your ideas. If you've got folks that you think can present on those topics, we'd love to have that as well. And the more interaction we get from you, the better the delivery and the better topics we can have, not only for our virtual meetings that are coming up, but also our big face-to-face meeting in October. So thanks everybody for attending, and we'll look forward to seeing you again soon and in person soon as well. So thanks everybody.
Thank you.
Follow us on LinkedIn and Facebook to stay up to date on our events and to see our industry-specific content. Thank you again for joining us, and if you have any questions, please feel free to reach out to us at askus@lgt-cpa.com. Have a great day, and we look forward to seeing you next time.